Great. Thank you so much to Lynn Poirier, our communications director there at the Palm Beach County Bar Association, to ensure we get started promptly. So hello to everyone and welcome to the Palm Beach County Bar Association's Town Hall meeting with 15th Judicial Circuit Chief Judge Glenn Kelley. My name is Scott Smith and I am the current president of the Palm Beach County Bar Association. I will also serve as moderator during today's Town Hall meeting, primarily to introduce and assist Chief Judge Kelley with today's meeting and anticipated questions to be received during the meeting. In that regard, Lynn has advised me that there's a Q&A section down at the bottom of your Zoom screen. Even I can see it, so you'll be able to do it if I can see it. And you can type your questions in there. One of the things I'll be during the meeting is looking at the questions, reviewing them. I may ask them, bring them to Judge Kelley's attention during the meeting, or we plan on reserving about 10 minutes at the end of the meeting for the anticipated questions. Before we get started, I of course want to take this opportunity to say thank you to our sponsors for today's Town Hall meeting. Without the generosity of our sponsors, events such as this one would just simply not be possible. Thank you to the following: Brinkley Morgan. Thank you, Julia. I know you're out there somewhere in Zoom world. Fisher, Potter, and Hodis. I'll certainly say hello to and thank you to Ben when I see him. Florida Lawyers Mutual Insurance Company. Keen Law. Thank you, Hampton. Great job, brother. Searcy, Denny, Scarola, Barnhart, and Shipley. And thank you to that law firm for continuing to be such a generous sponsor of the Palm Beach County Bar Association and so many other voluntary bar associations. And lastly, Smith, Ball, and Baez Injury Lawyers. I promise we sponsored it. I didn't slide that in. I also want to remind everyone that the Palm Beach County Bar Association is a voluntary bar association with nearly 3,000 members that is in its 100th year of existence, which is quite remarkable. Founded in 1922, the mission of our association is to serve its members, foster professionalism, and enhance the public's understanding and awareness of the legal system. We are also very active in providing numerous public service activities and giving back to our wonderful Palm Beach County community. In that regard, the Palm Beach County Bar Association's Young Lawyers section will be putting on and hosting its 6th annual Run for Justice 5K this Saturday, September 10th at 7:30 a.m. at Okie Healy Park on Forest Hill Boulevard. I've been told that current Young Lawyers section president Michael Krantz intends to run a record 5K time. So that unto itself is great reason to get out there for this tremendous outdoor activity. Go get 'em, Mike. In addition, the Palm Beach County Bar Association is hosting a luncheon at the West Palm Beach Marriott on Wednesday, September 21st at 11:45 a.m. to 1 o'clock p.m. with current Florida Bar President Gary Lesser giving us an overview and update of the state of the Florida Bar. We greatly appreciate Gary finding the time to deliver this address and update to all of us during his busy schedule this year as our Florida Bar President. Thank you, Gary. You're a good man. Okay, to our town hall meeting of today. We are very fortunate to have Chief Judge Kelley here with us. He is immensely busy with his many duties and responsibilities as our Chief Judge here in the 15th Judicial Circuit, so we also greatly appreciate the judge finding this time for all of us. Before I ask Chief Judge Kelley what is going on at the 15th Judicial Circuit, I'd like to remind us that Glenn Kelley has been our Chief Judge since July. Judge, I think I mistyped this down. Since July of 2021. 21.
Last year.
I had 2020, and I
just completed my first year.
Since July of 2021. Judge Kelley was appointed to the circuit bench in 2006. Judge Kelley received his undergraduate degree from the University of Florida and also graduated from U.S. College of Law. Prior to becoming our Chief Judge, Judge Kelley served in our civil and criminal divisions here in Palm Beach County. I certainly had the pleasure and honor of having several cases in front of Judge Kelley while he was on the civil bench. Judge Kelley, thank you a ton for being here with us today. I recognize at this point, everybody is ready for me to stop talking. So as I indicated, please allow me to ask you, sir, with the initial question, what is currently going on or taking place at the 15th Judicial Circuit?
Well, certainly a broad question, Scott, and thank you for having me here. And I appreciate the opportunity to speak to the Florida Bar that obviously always supports the judiciary and the things that we're trying to accomplish here in the 15th Judicial Circuit. So I appreciate the opportunity to speak. Also, I do want to emphasize that if a question comes in, and Scott, if you think it's appropriate to interrupt me during the course of anything I'm saying, I welcome that. I think questions are probably the best way to get out important information, because you can try to anticipate what people want to know about, but when you hear their questions, you know what people want to hear about. And so I encourage questions at any time at the end of our session or during the course of it. I realized we were having a discussion right before we came online here about when the last time was that we had one of these town hall meetings. And I think it was at least 6 months ago. The last one I recall was in December. So a lot has occurred since then. What I want to do primarily, rather than try to recap the entire 6 months, which we probably cannot do in the time allotted, I want to focus on kind of the major events which have occurred over the summer, because we've had a lot of significant things happen here within the circuit during that period of time. Probably the most significant change that has occurred is the division of the family and probate divisions, which occurred effectively on July 5th of this year. Just by way of background, what led to that division and what we believe was a needed division, or at least I did and made that decision. We were basically handling probate through a hybrid system where each of our 9 family law judges had a full family docket and also had a probate docket. And it really was not proving to be a very workable model, primarily because, or at least in part because of the fact that we've had some staff issues with case managers in probate. We've gone from 5 case managers to 3, not able to fill those 2 positions. Our 3 case managers responding to 9 different judges was becoming difficult. Also, it was very, very difficult, frankly, for our family judges who have extremely busy family dockets to handle a family docket and also focus on a probate docket. And so what we were seeing within the circuit is a backlog in probate, which basically manifested itself in estates not being open for significant periods of time, long waiting periods for processing orders. And so, at least from my perspective, we needed to do something and make a change. And so the change we made was to basically open 2 probate-only divisions. To accomplish that, and this was all effective again as of July 5th, we did have to close down 1 civil division. So we sacrificed a civil division, and we had to close down 1 family division. And so we closed a family division, a civil division, and created 2 probate divisions. Those probate divisions are currently being manned by Judge Chuck Burton down in South County and Judge Laura Johnson here in Maine. And so we made that change, and it frankly has made a difference in the short period of time that we've had to deal with the 2 probate divisions versus the 9 probate divisions. In terms of processing orders, before we made this division, it was taking over 6 weeks to process orders. I've been told that we're down to a week processing orders now, so a dramatic change in the time required to process orders. It's not perfect yet. We understand that. There's still delays. I know some are still impatient, but we've made a lot of progress in a short period of time. Our case managers, their workload is changed significantly because while we have 2 probate judges focusing only on probate, they can do more of the work that would normally have to go to case managers. And so to give you an example of how that has changed, we all have a queue, or it's basically a place where orders go to be signed, and they can back up. The case managers' queues for review of orders and recommendations to the probate judges before this change, they had approximately on average 800 orders pending in their queue. We've gotten that down to 40 or 50 orders pending in their queue. So there's been significant change with respect to the processing of probate cases. I will caution everyone, as I said, this is still a work in progress. One of the difficulties with probate, and we may have some questions about probate as we go through this, is across the state and certainly within the 15th Judicial Circuit, probate filings are way up. It's the one area where filings are rising. Civil, circuit, and county, basically flat or going down. Criminal, the same. Family is up slightly. Probate is up significantly across the state. In fact, if there's a backlog anywhere across the state, it's in the probate divisions. So there's a lot of work to do there. And you may not appreciate the amount of work that our probate judges have to do. So I realize there's some impatience still with the processing of orders, but they receive into their individual queues 100 to 150 orders a day sometimes. And they all have to be reviewed and processed. And it's really an endless process. And so it's very difficult for our judges to get through that. But we've made the change, and we really do think that it's making positive progress with respect to the handling of probate cases. One of the consequences of doing this division is that we had, as I said, we had to close down a family division, and that division was Division FD, which Judge Johnson previously had. We had a plan in place for Division FD, which would accomplish the closing of FD without overloading our other family law judges. And the plan was we placed Judge Zuckerman, who is a TD judge, into Division FD. And the idea was that Division FD would basically be worked down over the next 6 months so that by the time it was ripe for transfer of cases or reassignment of cases to the other family law divisions, that the numbers would be fairly low. That plan changed dramatically because Judge Francis, as you all know, was appointed to the Supreme Court. With Judge Francis leaving us and leaving her family division, we had to completely revamp the plan with respect to Division FD, and we had to immediately begin reassigning the cases. And so we've been through that process. All of those cases are now reassigned to the other 8 remaining family judges. We may have some questions about Division FD, so let me just discuss a little bit about the process in closing down FD, and it may or may not answer some of the questions we have. With respect to Division FD, because we anticipated that division hanging on at least through December under the original plan, Judge Zuckerman had already set a bunch of final hearings and trials and other matters from here through December. What we've tried to do is to preserve as many of those as we can, because we realize when those cases are reassigned to new family divisions, the family judge may already have matters scheduled on their calendar, and they can't just simply rearrange their calendar to hear those matters. So what we did is we tracked all of the hearings, and primarily final hearings and trials, but also some other hearings. We tracked all of the hearings that were in the FD division. We provided and compiled a list of those hearings. We sent out those lists to the other family judges to whom the cases are now assigned. We asked them which they could cover and which they could not. We basically prepared a spreadsheet, and we've determined which final hearings or trials our family law judges cannot cover. And what we're going to do with final hearings and trials is they'll remain set as they were in Division FD, and we're going to make an attempt to have those covered by a senior judge or by a volunteer if we can. So we're going to preserve those final hearings and trials that were in FD. We may not be able to do that with all the hearings that were set. There may be a requirement that hearings be reset in the newly assigned division. There's only so much we can cover for FD given the shortages of judges that we have right now. But that's the plan. It's working fairly well. I can't tell you there's not a few glitches that have come up. And obviously, anytime you do this, there's a certain level of confusion with the litigants. We've been trying to push out information through the bar as best we can to let people know what's happening. And the best thing I can say is that if you have a question about a former FD case, you should have received a notice of reassignment. You should know where the case is now assigned, and you can contact the now assigned judge, and he or she could give you some information about the status of your trial or order. But as I said, if you've got a trial or a final hearing that was set in FD right now, unless you hear otherwise, it'll be heard at the time that it was set, and we'll get a senior judge to come in and handle it. So the major event that occurred over the summer was the division of family and probate, and frankly, the unexpected rapid closure of Division FD as a result of Judge Francis being elevated to the Supreme Court. Also occurring simultaneous with all this was the normal rotation we do in July. The rotation this year was a little bit different, not as we typically do it and not as we prefer to do it. It turned into essentially what was a phased rotation. And the reason for that is that at the time that we were preparing to rotate, Janice Kaiser's circuit division was open, or her circuit seat was open, and we were waiting on the governor to make an appointment. And I did not feel it was appropriate to make a complete rotation until I knew who was going to take that seat. And so I knew what I was working with and where that judge should or could go. So what we ended up doing is a phased rotation. Initially, we just rotated 3 judges. That would have been Judge Johnson stayed. She basically stayed where she was at, but she gave up Division FD. Judge Burton left Gun Club and went to South County to take up that probate division, and Judge Volker graciously rotated out to Gun Club to take his position. Then we had a later rotation once we knew that Judge Serber had been appointed from county to circuit. We were able at that time to do a second element of the rotation, or second phase, and we rotated Judge Serber from a county position to the juvenile position in South County. At that time, we also were able to bring up Judge Delgado to the civil division. Judge Haffel moved to the juvenile division. And the final phase was basically we did move Judge Silver to the open county civil position down south, leaving an open county criminal position here. So it's been a busy summer with rotations and with trying to accomplish what we were aiming to do in probate and in family. So those have been the primary things that have been happening. A few other things that have happened, though, and we've discussed these briefly, and I've tried to push out information on this, is that over the summer, the Supreme Court did adopt new changes to the rules of civil procedure and to the rules of juvenile, family, really across the board, dealing with primarily remote appearance in court. And basically, it's going to make permanent many of the rule changes that we saw by emergency AO during COVID. Some of the high points is it allows remote proceedings pretty much across the board unless there's a due process requirement, which is basically generally in criminal. So unless there's a constitutional mandate that it be in person, it permits remote proceedings. It permits the remote swearing of witnesses, which is something we've been doing during the course of COVID based on those emergency AOs. And so kind of across the board, it legitimizes, I suppose, that's one way of looking at it, remote proceedings. And the whole question about whether that's going to continue has been answered by the Supreme Court. It is going to continue. Attorneys may like this. I'm not sure about the judges. Even has a rule that states if it's a 30-minute or less non-evidentiary hearing, if an attorney asks for a remote proceeding, it has to be granted absent good cause. And so I don't know yet. I haven't met specifically with Judge Nutt, my administrative judge in civil, but my guess is UMC is going to stay remote. That given the fact those are short hearings, probably across the board, UMC will now remain remote. It does remain discretionary at this point with the assigned judge, but since any lawyer can ask for a remote hearing for anything under 30 minutes, and those are supposed to be 10-minute hearings, I think probably the default is going to be remote. But we'll be coming out with some more definite statements about that in the future. But that's a significant change to the rules and something that we're incorporating into our practice here. Other things that have been occurring, we've been trying to work on some technology in the courtrooms. If you actually come to court, I don't know how many of you actually come down to the courthouse anymore. But if you do come down for jury trial or otherwise, you're going to see that we have a digital sign project going on here at the courthouse. What that is the bulletin boards. You all remember the little bulletin boards outside the courtrooms where judges would pin up little notices or divisional instructions. Those are being replaced by monitors, basically large television screens. And that's happening throughout the courthouse, not just outside of courtrooms, but in certain key areas and hallways. And the purpose of that is to create basically a digital board, and we'll be able to post digitally news with respect to the division, dockets if appropriate, a docket listing and other information that the assigned judge believes is important. This is a project, believe it or not, that was made possible now out of pandemic relief money. We have received from the legislature, that is the circuits within the state, pandemic relief money for the last 2 years. We anticipate we'll probably receive some in the third year. The difficulty is a lot of it can't really be used for much because we can't hire people at the rates and salaries being offered for temporary positions that might be useful, like case managers and staff attorneys through that pandemic relief money. So we've been able to convert it to other things. Senior judge time we've been able to convert it to. And we're able to actually get out of that pandemic relief money about $300,000 to put to the digital sign project. And it was the money that you either spend or lose. And so we had to figure out a way to do it. The county very quickly assisted us with the wiring, and we were able to accomplish it within the time frame that basically the funding permitted. And so that'll be going up. I don't think they're going to be online for a few more weeks. They're physically being installed now around the courthouse. If you come to the 11th floor, for example, you'll see them. We're also trying to upgrade some of the technology we're using in our courtroom. I'll be meeting with the judges later this month to demonstrate some of the technology that we are trying to incorporate. Some of it has to do with cameras, 360 cameras in the courtroom. Some of it has to do with basically wireless technology to use the monitors that are in the courtrooms. One thing that we're looking at, and we're struggling with, but we're looking at, would be to develop a manner in which jurors can view evidence that's being placed up on the overhead screen or on the monitors in the courtroom. A couple ways to approach that we're looking at. One is to give them basically their own tablets. That's not the preferred way, but we're looking at that. We're also looking at ways to install screens on the jury boxes the way that you may see in federal court. That's a much bigger project. It requires wiring by the county. It requires figuring out what kind of brackets can be attached to the jury boxes. So there are some technical challenges there, but we're trying to basically upgrade the technology that we're going to be employing in the courtroom. And I'll mention a little bit in terms of goals for the future when we get into the build out of the 7th and 8th floor. In new courtrooms, we're going to try to incorporate from the beginning new technology, which hopefully will make it an easier place to try a case and easier to use the technology that's now available for evidence and for witnesses appearing remotely, which is another thing we're now able to do by virtue of, at least on the civil side, by virtue of the rule changes that have occurred by the Supreme Court. So that's kind of what's been happening. I don't know, Scott, if you have any questions about what's been happening, but it's been a very, very busy summer, primarily in family and probate, but also with the rotations with new judges getting into the civil division. Obviously, I would be remiss if I did not mention the loss of Judge Janice Kaiser. That was a big event over the summer, a very sad event, a very great loss for the circuit, and we still mourn that. And Greg Kaiser should be getting back into his division starting this week. And so we're going to welcome Greg back. But obviously, that was an event that shook us all. We're very saddened by the loss of a very, very, very fine jurist and a very, very fine friend. So we do continue to, keep Greg Kaiser and the rest of the family, his children, in prayers and thoughts, because it's obviously a great loss. So, Greg, I don't know where you want me to go next. Scott, we can talk about, challenges coming up or future events or.
Well, Judge, first, on behalf of the entire Palm Beach County Bar Association and all of our members, please allow me to offer our deepest sympathies to the Kaiser family and to all other members of the judiciary who lost a colleague and a close friend. Please let us say that. I know we've said it before, but once again. Judge, there were a few questions that were provided before today's date that I think are germane and relevant to what you've already talked about, the division of probate and family. I think in many ways you've answered them, but I don't think I'd be doing my job if I didn't bring those up now. So I'm going to read one of those questions that I
Sure.
have here in front of me. And the question is, are the attorneys, and bear with me, I have to put the glasses on. I'm getting up there. I'm not as old as Greg Coleman just
I
yet,
have
but-
mine right here in case I
All
need
right.
it.
I hope Greg heard that. All right. So the question is, are the attorneys who had trials and evidentiary hearings set in Division FD after August 31st, 2022, responsible for getting those hearings reset, or are they still set and now assigned to the new judge's division to be heard by the new division or a senior or alternate judge?
All right, let me start with, because there are two parts to this. The first part is final hearings and trials. If you have a final hearing or a trial, like an adoption is a final hearing, okay? If you have a trial or a final hearing, you do not need to do anything at this point. It is set on the date and time that it was originally set. The final hearing or trial will either be heard by the newly assigned divisional judge or by a senior judge or by a volunteer. What we did with respect to all hearings, whether it was a final hearing or a trial, is we first reached out to the newly assigned divisional judge. And those judges did the best they could to work those calendar events into their own calendar. So they would look at their calendar and say, well, I can handle this trial, or I can handle this hearing. And then they got back to us and said, I can handle this. We don't need a senior judge. So if it's a trial or a final hearing, at this time, you do not need to do anything. We are going to try to preserve those. A lot of people have waited for their trials for a long time, their final hearings for a long time. Let me deal with hearings, whether it's evidentiary or otherwise. We followed the same process as we did with final hearings and trials. That is, we reached out to the newly assigned divisional judges and said, is this something that you can cover? If they could cover it at the same time, they told us, and it'll go forward. There are a couple of hearings that the divisional judges will not be able to hear that will need to be continued. You will receive notice that this hearing needs to be reset. And so ultimately, yes, you'll be responsible for coordinating a new time, a new date and time, but you will receive notification either from the divisional judge that it's been assigned to or from someone in court admin. More likely, it's going to be from the divisional judge's judicial assistant, but they will contact you and say, this particular hearing, you're going to have to reschedule. When we went through the process of, basically the emergency closing of Division FD, because that's what it became, the notification, we didn't know, we had very short notice with respect to, Judge Francis's appointment. It was just a matter of weeks. We had to make the decision to start shutting things down. We did make the decision that we're going to preserve final hearings and trials, but we couldn't make that commitment with the regularly scheduled hearings. Now, anything set in front of a magistrate, let me just say this, anything that's set in front of a magistrate as opposed to a divisional judge, that will remain set, period, because it was already in front of a magistrate. There's been no change in the magistrates. And so if it's a matter that's set in front of a magistrate, it will remain set. So where practitioners need to be careful is not an evidentiary, either an evidentiary hearing or that's not a final hearing or any other type of hearing. Those are the ones not set in front of a magistrate, but set in front of a judge. Those are the ones that are subject to being changed. Looking at our master spreadsheet, there are not too many of those, really, only a handful. And the attorneys will be notified timely, hopefully, that those need to be basically rescheduled. In fact, I was meeting with our court admin staff yesterday, going over our spreadsheet to make sure that it's accurate. I'm going to send it out again to the judges, get their feedback, and then we'll make sure that we're telling those folks that need to reschedule something, they need to reschedule it. But there will not be very many of those, frankly.
Okay. Judge, another question I think in this area that you have answered in large part, but again, just to be thorough, I'm going to read the question. It's actually two questions from the same individual. First part asks, has there been any discussion about returning to ex parte in-person probate proceedings so that estates can be opened rapidly? Second part of the question or statement, we used to be able to have letters of administration issued the same day as the ex parte proceedings.
The answer to that question is it has been discussed. but it is not likely to occur for a couple of reasons. Frankly, I remember the old ex parte clerk. I mean, to the extent I dabbled at all in probate when I was in private practice, which was not very often and probably bordered on malpractice, I would go over here to the ex parte clerk. They would take a look at your forms that you'd get from the Florida bar. You'd literally order the forms, fill them out or type them out, and give them to the ex parte clerk. They'd look at them, tell you they're good, send you in, or tell you what you're missing. And I know people, really enjoyed that part of the practice. I mean, it was very easy, it was very quick. But one of the reasons we can't go back to that is number one, it does require review before you go in and see the judge by someone. And our case managers just are too busy to be able to commit to doing that during the week. Secondly, you got to keep one thing in mind, and it has to do with any type of what you'd call walk-in court, is the way we process orders now. It's not a matter of walking in and handing an order to a judge. The order's got to be uploaded, reviewed, and signed electronically. And so what we're hopeful of is that whole process is going to get down to the point where I know we're not there yet. And part of it is the fact that, the filings are just so heavy right now. But we're going to get to the point where I think that turnaround is pretty quick, which will mirror what's happening in Broward and other places in the state. I'll say this about probate in Palm Beach County, because I looked at this when I was trying to figure out what to do about the issues we were having with delays in opening estates and what we were doing differently than other places. As I said, I don't think our hybrid system was really working given our staffing problems. But beyond that, Palm Beach County has a heavy filing of probate compared to like-sized circuits around the state. You can go around and look at, Hillsborough County, up in Duval and Jacksonville, even our neighbor to the south, in Broward. Miami-Dade is much higher than us, obviously, given the size of the county. But you look at like-sized circuits, and for whatever reason, I don't know whether it's demographics or what the issue is, but our probate filings are extremely heavy in Palm Beach County, heavier than other like-sized circuits. So there's just a lot of work to do. It was frankly discussed. Judge Burton, Judge Johnson discussed, do we do this? And basically the conclusion that they've reached is it's really not in this modern world the efficient way to do it, nor do they really have the resources to do it. Now, what I would suggest, though, is if you're having a problem getting through, always check the judge's divisional instructions as to what to do. Because I know Judge Burton, for example, I can't speak for Judge Johnson, but if there are issues, you can come in on UMC. So there are ways to, if there's a problem with the file, to kind of get it in front of the judge. But we're not going to go back to that. I remember fondly the ex parte clerk and how efficient it was, and the ex parte clerk was always so nice and she'd always help you and tell you what you needed. And I know a lot of practitioners probably miss that, but I don't think we're going back.
Okay. All right. Thank you, Judge. We've gotten a couple more questions in that I think I'm going to hold until we get to that last 10 to 15 minutes where we'll have those questions asked to you, Judge. But I think I'd be remiss today as the moderator if I didn't ask you about and touch on, and I have to read it because I always forget the name, the work that's being done by the Judicial Management Council's work group on improved resolution of civil cases. And I think by now most of us have seen their final report of November 15th of last year and been to the Supreme Court's website to see what's going on in that particular amendment case. Judge, can you tell us what you understand is currently happening?
Yeah, I just call it the work group. I just avoid the long title, just call it the work group. What's happening at this point is that the work group has submitted its proposals to the Supreme Court. Supreme Court asked for comments, and they've received a lot. As you might imagine, the rule changes are dramatic, and so there's a lot of people that have an interest in what's going on, and so they've received a lot of responses. They've received requests for oral argument. And at this time, what the Supreme Court has done is they want the work group to respond to all of the comments that they've received from members of the bar and other interested groups. And it's so much work for the work group that they've actually had to ask for a couple of extensions of time. And I think they're working right now on an extension of time. So the work group has not fully responded to all the comments. here's what I would anticipate happening based on discussions I've had with some of the members of the work group and just kind of a working knowledge of how the Supreme Court's been working through these things. I would anticipate that more likely than not, the Supreme Court will set an oral argument on these rule changes, just as they did on the rule changes with respect to remote proceedings that recently were adopted. My best guess is that oral argument will probably occur sometime in December, and then that the rules will be adopted in some form next year. My best guess would be March, April, May. They would be adopted just based on their prior practice and timeline as we saw going through the remote rule changes. And so that would be my best guess. I will tell you that I believe there will be some minor modifications to what's been proposed. I can also tell you my belief is that in large part it's going to be adopted. And so it is going to be a reality that we're going to have to deal with. And it's a seismic change in the way civil practice is conducted throughout the state. So we're all going to have to get ready for that. I think as we get closer to it and we know really what it's going to look like, what they're likely to change, not likely to change, we probably should start preparing for that as a bar and as a bench. And I've already started looking at some of the reporting requirements that may be placed on me with respect to the cases that are presently in the civil divisions, and figuring out how we can best do that, how I can get our judges kind of ahead of the game so we don't have issues with respect to expectations by the Supreme Court. And one of the things that we are working on, I can mention this, I think it segues okay into the question, Scott, is one of the things that Judge Nutt has been tasked with and is working on as administrative judge in civil is a revision of basically our AO and the manner in which we do differentiated case management. Over in Hillsborough on the 13th, they've come up with basically an automated system where the case management order, complete with deadlines, is created at the time that the case is filed. Now, obviously, there have to be modifications to that as you move forward. You may not be able to, completely comply with every deadline set at the beginning of the case, but it kind of streamlines the process and sets the expectations. And so we're working on that. Judge Nutt has been in communication with the administrative judge in Hillsborough. It requires some cooperation from the clerk's office because basically they have to input information at the time of filing. Our IT people are working on it. So we're trying to automate that so that we have less required of our judges in terms of continually setting case management conferences, getting lawyers in to try to get them to enter an order for case management. That takes up a lot of judicial time and labor. And the more we're doing that, the less time we have for hearings and trials. And so we're trying to automate it as best as possible. But those rule changes are coming and, we're going to have to get ready for them and do the best we can with it.
Okay. Judge, I'm likely asking you to speculate a little bit here, so please don't object, but has there been any indication to you or discussion you've had with anybody in the know as to when the work group's seismic changes, as you've described them, would go into place or take effect?
Again, it's going to be a best guess. I mean, I would think probably next summer. My guess would be that they use the July 1st date, which is a date that the legislature uses a lot when they adopt new statutes. Could be later. I mean, this last time around, they made the remote changes effective as of October 1st, and they adopted them, basically in July. There'll be some lead time. So my best guess would be summer, but it could be as far out as October, but it'll be sometime, my best guess, mid-year to, fall of next year is when these rule changes are going to hit. I would say this, though, we do not want to wait until then to begin thinking about and preparing for the manner in which we're going to handle this. And I know my judges are going to have to do that in the civil divisions, particularly with respect to trial dockets and how they're going to handle that. And so I'd like to look forward and say, okay, we know that most of this is going to hit. So let's start talking now about, what it's going to look like and how we can best be prepared for it. And I would suggest all members of the bar do the same thing. Start looking at the manner in which you're practicing law now in the manner in which it's likely to change, and things that you can start doing now to kind of fine tune your practice, develop, best practices within your firm, knowing you're going to have to do things differently. And so that will be my recommendation. And then when it hits, we'll be better prepared to deal with it.
Yes, sir. In the interim, Judge, before the work group finalizes their work and this becomes official, are we still being governed by or subject to the administrative orders here in Palm Beach County, that being 3.107 and 3.108, dealing with the differentiated case management plan?
We are. Those rules are still in place, and they were adopted pursuant to an AO entered by the Supreme Court. It was a COVID mitigation AO. It really was a somewhat odd place to place it, perhaps, but that's when it came down. I think the Supreme Court's thinking was that we were going to have a backlog as opposed, because of COVID, and they wanted to get ahead of that. And so they put the differentiated case management in an AO. That Supreme Court AO is still in place, and it still requires us to have AOs in place to implement them. So those two AOs will remain in place. Now, one of them is going to have less significance. One of the AOs has to do retroactively, when we had to go back and look at cases backwards and figure out what we're going to do in those cases. That AO probably is not going to change much, and everything that's going to happen in those cases has probably happened. Going forward with new filed cases, there'll be an amended AO at some point. Again, Judge Nutt's working on that.
Okay. Judge, with respect to UMC hearings and those hearings that are 30 minutes or less, will there be an option for a lawyer, a practitioner to appear in person, or will that just not be available?
Well, it's going to depend on the, I have not at this point contemplated entering an actual AO telling the divisional judges how they must conduct their UMC or their special sets under 30 minutes. That may be something we have to look at. We'll try to develop as much consistency as we can. I would think that with respect to UMC, that most are going to just have a full remote UMC. With respect to 30-minute or less hearings, I also suspect that we'll probably adopt a hybrid policy, that if somebody wants to appear in person, they'll be able to come in person, and those that do not can appear, by Zoom. One of the reasons why we're looking at improving our technology in the courtroom with 360 cameras and other things to improve what we're doing, because we anticipate both in trial and in hearings that there's going to be hybrid proceedings. And so we need hybrid proceedings are a little more difficult, obviously, to pull off, but I think they're also a wave of the future, and we're going to have to prepare for that. So I think with respect to hearings, generally 30 minutes or less, there's probably going to be an option. I do not know whether that's going to be carried over to UMC, because you have so many hearings coming in on UMC. Creating hybrid there could be difficult, although I think it can be done. I mean, as we improve the technology in the courtroom and look at ways to make it easier, I think that's something that probably could occur. We could have hybrid UMC. Right now, nobody's clamoring to come back for UMC, not the practitioners, not the judges. So it seems to be working remotely. 30-minute hearings, a lot of judges want people here. They're not all that happy about the new rule change. So we'll see how it goes.
Okay. Judge, sort of a good segue into one of the questions we've received from Andrew Kwan, who knows a lot more about technology than I do. So he's eager to know. His question is, when do we anticipate the courtroom technology upgrades to be complete?
Well, it's going to be a process. We're going to have to roll. First of all, there's budget requirement. This equipment's expensive, so as we purchase the equipment, we'll be implementing it. We're going to start probably in our jury trial courtrooms because they have a greater need of it. It may start primarily or beginning criminal, because a lot of the civil practitioners kind of bring in their own people, and they can they're more able to staff IT people and assist with remote proceedings and technology. I would say it's going to be over the coming year. Basically, we're going to start rolling out as we can purchase equipment, as the judges tell me what they want in their courtrooms. We're going to do it. I'm really interested in the viewers for the juries, but it creates some technical challenges. And so over the next year, we're going to try to roll it out. I can't tell you it's going to happen next month or even the month after. It just depends on what the technology is and what we're trying to accomplish.
You referenced earlier, Judge, the build out of the 7th and 8th floors. I always think it's
Yeah.
neat when you're on the elevators and you happen to be with somebody getting off there and you see how it's just completely empty. When is that likely to occur? Is the money already been appropriated?
Yeah, that's one of the more exciting things that we've been able to accomplish recently, and that is the build out of the 7th and 8th floor. Where we're at now is finally we've gotten to the point where a comprehensive plan has been approved by everyone. It's gone in front of the county commission. They've approved this long-term plan for judicial facilities. It includes the build out of the 7th and 8th floor. One floor will be used for new courtrooms. The other floor will be used for administrative space. We're going to move administrative function from the 5th floor to the 8th floor and build out courtrooms on the 7th floor is the current plan. What's happened now is that the county has gone to contract with a design firm. And so we're now in what's called the design phase. As I understand the design phase, we're going to go, from basically architectural plans, and I've already met a couple of times with the architect to start looking at, courtrooms and what they should look like, all the way through permitting. That process is, to be honest with you, I probably will not be sitting in this seat when construction is completed because I'll probably be done with my term as chief judge. But the plan is that the design phase is going to take about 18 months. And after that, we'll go into the construction phase. The county currently is looking at a plan where they do construction simultaneously on 7 and 8 instead of phasing it. That will save the county some money in terms of the contractor's general conditions and basically their supervisory costs. And so it's exciting. We're going to try to build out the courtrooms with as much technology as we can fund and as the county is willing to pay for, which I think they'll be reasonable with respect to that. I think they've shown that they view technology as something that's important, and I think they'll assist us with that. Whether it looks like the courtroom that Jack Tudor has in Broward, which is very high tech, we're hoping it'll look something like that. But it's very exciting, and it's something that's coming up. It's something that all the chief judges before me have worked on for the last decade. And I just happen to be in a position where I've been able to get to the design phase contract. There is money for it. The county has that money appropriated, and so we should be moving forward with that.
Okay, that's exciting. Really is exciting.
It is.
Judge, a few questions have come in via the Q&A application, and one of the questions is, and this may be specific to each particular judge, but the question is, how, if at all, may a litigant find up-to-date trial docket information when a juris division does not keep its trial docket up to date on the division website page?
Well, that's kind of a hard question because what I would tell you to do is to go to the divisional website page normally. I mean, that is a function of each of our individual trial judges. We are certainly hopeful that and each one of them track that information differently and publish it differently. And so you kind of have to go to each division and inquire or look at their divisional instructions and see how they're going to publish it. Whether they're going to publish a list. I know I used to try to do that in the division that I was running, kind of a running list of the trials. It's certainly something I can mention to the trial judges that folks are looking for is updated information with respect to trials. But each judge gets to handle that the way he or she deems appropriate, and some will give you very detailed information, and others, for whatever reason, would rather not publish that information. So you'll just have to look at each division to see how they're going to handle it.
Okay. Michael Gelfand makes a good point here about the recent change to the Florida e-filing portal and how we're not going to be getting the attached pleading, sent back to us, and there'll be a link that we'll have to go to get the attached pleading. Can you comment on that, Judge? Do you have information about that?
I really don't have much information about it. I mean, that's, in fact, I probably, to be candid with you, I wouldn't know how to file a document if I had to. I mean, I know how to process an order. I know when it comes into our queue, I know how to handle our system, our JVS system, our judicial viewer. But in terms of the e-filing, it's not an area I have a lot of expertise with. I know they keep tinkering with the system. I mean, I'll just say, kind of parenthetically here, e-filing really has changed not just the practice of law, but the manner in which judges have to go about processing their work. And there are arguments on both sides about whether it's been a good change or a bad change. I will tell you this, that e-filing has created a situation where lawyers can file 24/7. And lawyers do file 24/7. And so what ends up happening is our judges really get backed up and have a lot of work to do with respect to their queues, which is the area where the orders, when you file a proposed order, that's where it goes, into the queue. Now, you're just talking about filing generally in terms of filing a motion. I understand the question doesn't have to do specifically with orders. But the whole e-filing system has created a situation where judges are basically married to their queues. I mean, it used to be as a judge, you went on vacation, you didn't have much to worry about. Now you take your laptop and you work on your queue. Because if you don't, when you come back, you're going to find, 500 orders in your queue that you have to process. And you have to go through and look at each one, make sure it's right, make any revisions you need to, and then, process it electronically for signature. And so it's a lot of work. I can tell you, just by way of example, Judge Johnson and Judge Burton in probate, the amount of work that comes into their queue is so heavy. They were both at the Circuit Judges Conference a couple of weeks ago. They were literally sitting in the conference in the educational classes we have with their laptops open, processing orders. They'd go back to their hotel room at night and they would process orders. And if they don't, they're overwhelmed. It's just, that's how much work's coming in. And probate is a significant problem, but to a lesser extent, same occurs in family, same occurs in circuit civil. Any civil division that has a queue with orders coming in is a situation where you have to stay on top of it. And if you're in trial, you can't be processing orders. So e-filing has created some challenges, not just for the lawyers, but for the judges.
Sure. No doubt, Judge. It's coming at all of us from every direction there is. Michael Lampert has a few questions. His first question, how are and will be mediations impacted by virtual and the coming rules?
But the rule changes do. In fact, if you look at the new rules, I guess everyone looks to what's presumptive and what's allowed, okay? My recollection of the new rules that were just adopted by the Supreme Court on remote proceedings is presumptively mediation is in person. It's still in person, but it provides that mediation can be remote by stipulation of the parties or by order of the court. And so the presumption is going to be in person. That also applies to depositions, by the way. There's a specific rule on depositions, on mediation and arbitration. And presumptively, they're in person. Either can be done by stipulation remotely or by court order. And so you'll start with that. And if you can't agree by stipulation, you'll have to file a motion with the court and convince the assigned judge that it needs to be remote. But you can do it by stipulation anytime you want. Okay. Under the new rules. You can do it now too by stipulation, but under the new rules, that'll be codified.
Mr. Lampert also poses another question. What issues is the court and the clerk having with pro se litigation?
Well, I don't know what issues the clerk's having with pro se litigation. Pro se litigation is always tough for judges, as you know. I will say this about pro se. One of the things that did occur in the new rule change that I think is significant, because I think it's going to assist us immensely in getting things set and done, is with respect to pro se litigants, it reverses the presumption with respect to e-service. Under the old rule, a pro se litigant was not required to provide an email address unless they opted in and gave an email address, in which case, under the old rule, they didn't opt in. You had to mail copies of orders to them old-fashioned way. Under the new rule, it's presumptively the other way. Presumptively, a pro se must provide an email address, and they will be served electronically unless they opt out and demonstrate to the clerk why they cannot be served electronically. So in terms of problems the clerk's office may have with pro se, it would just be the typical problems you have with any pro se. They're not lawyers, so they're not aware necessarily of what they're doing. And it creates complications many times as they try to exercise their rights without an attorney representing them. I'm not aware of any specific problems the clerk's office is having, though, with respect to pro se, but that is a significant rule change, at least from our perspective, because it'll make it easier for us to serve orders. And I know it'll make it easier for attorneys with pro se litigants to serve papers because you can do it electronically.
Judge, we have just a few minutes left. It's hard to believe this hour is already just about up. Is there anything else that, I failed to ask you that you would like to bring to our attention during this town hall meeting?
Well, there are a number of things that I didn't cover, and I probably won't have time to cover them in the time we have remaining. I will just hit, I guess, on some high points, and you may have to shut me off, Scott, if I go past time. But we do have some significant challenges facing the circuit that we've been facing. One is continuous judicial vacancies. It seems like since I've been in this position, since I've been in this position, I've not had a full slate of judges yet, and we're down 2 right now. And of course, every time that happens, we're scrambling to cover divisions. And so that's been a continuing challenge for us. Probably a bigger long-term challenge is staff. We're missing staff, and we're having a difficult time recruiting and retaining staff in key positions, including case managers. And that's probate. I've already mentioned. In family, we've got 2 family case law managers, which will be moving to judicial assistant positions, which are important positions that they're needed there. But it's going to create 2 vacancies in family case managers. Those positions are very difficult to fill because the salaries are not very high. Staff attorneys, same thing. We can't hire staff attorneys. Critical for due process, digital court reporters, which in the civil world is not that important, but in the criminal world is very important. We're required to keep the record. We're missing 7 digital court reporters. It's very difficult to continue to monitor criminal trials and provide due process court reporting, missing 7 digital court reporters, salaries too low, we can't hire them. And a lot of people will say, well, what about your senior judges? Can't you bring those in? We have senior judges, but we don't have a lot. We're actually short of senior judges. We don't have a lot of former retired judges that want to do that kind of work. The pay is not that significant compared to it's not significant at all. Matter of fact, and you can make a lot more mediating or arbitrating, and we just do not have a deep bench when it comes to senior judges. So those are some fairly significant challenges. I raise those, not to whine necessarily, although I'm sure it sounds like whining, but just to let you know that our judges are working as hard as they possibly can. I think I mentioned at a committee meeting the other day, I've never seen our judges work any harder in the 16 years that I've been here than they're working now. They really are. They're doing their best. But keep in mind, they don't have the support staff that they really need. And so when we have judicial vacancies, when we have staff shortages, when we have shortages of senior judges, the responsibilities, fall squarely on the shoulders of the judges, and they're doing the best they can. But it's my plea to be patient with your judiciary because we are being tested in that way. And we're getting things done. We're conducting jury trials. We're having hearings. But it is a challenge. And that challenge isn't going away immediately. I'll get new judges. The governor just convened the JNC for my 2 missing positions. But whether I get more staff, whether I get more senior judges, that remains to be seen. It's certainly a challenge. But we look forward to some of the other opportunities we have coming up in the next year. Continue to work with the bar to face those challenges, and I'm sure we'll get through it. We just have to figure out more efficient ways to do things. But I guess patience is what I'm asking for. That's my plea for my colleagues. Just be patient because we do have significant staffing issues and support issues that you can't see that are behind the scenes.
Yes, we all received yesterday, Judge, the email that the JNC's accepting applications for the 2 open vacancies for the elevation of Judge Francis and Judge Serber. Well, Judge, our hour is up. Thank you so much for giving us an hour of your time. If we were reminded of anything today, we understand, how busy you are and all of our judges are, and we greatly appreciate your public service. We truly do. We don't have to stop at an hour, but most probably need to get back to work. Is there anything else you would like to offer to us here in the next few minutes?
I think we've covered at various times the, new rule changes that are coming, the build out to the courthouse, the challenges that we're facing. There's not really much more I can add. I could get more specific on some of these topics, but we're getting by. We're in a position where we really do not have a significant backlog. Everyone always talks about the backlog. I've mentioned several times. Numerically, we do not have a significant backlog. We do have probate, filings going way up, and so our probate caseload is up, but and families up slightly. But otherwise, numerically, we're doing well. We do have some issues getting some of our larger jury trials through because obviously they backed up. So we have a backlog. For example, on the criminal side, first-degree murder cases kind of backed up, and we have to work those. On the civil side, I don't know whether Scott, you see and your practitioners see that you probably have some delays in your larger cases, your complex medical malpractice cases. Multi-week cases probably have backed up some because a lot of those had to be continued early on. And so catching up with those is going to take, it's going to take some work. And I know the judges are cognizant of that. But numerically, we're in good shape. I mean, I think I just got the latest report, since we reopened from COVID, we've done over 500 jury trials. And so, we're doing well, but, we have to keep working at it. And I know even though I think we're doing well with what we have, there are areas that we still need to focus on and try to get cases moved more efficiently and get some of those cases that, got derailed during COVID, back on track. And our judges are working on that. I think they're doing the best they can.
Thank you so much, Judge Kelley. We greatly appreciate your time. We truly do. And thank you to everybody else who was able to make today's Zoom town hall meeting. I hope you found it as productive as I did. I always love to get clarity, especially on where we're at with DCM and the work group's work. It's always good to be reminded where we're at. I'll just remind everybody, if you're running in the Young Lawyers section race on 5K on Saturday morning, start getting hydrated. It's already Thursday afternoon, so start preparing, especially if you're going to try to keep up with record-setting Michael Krantz. All right. Thank you, everybody. Thank you, Lynn Poirier. You bet, Judge. Thank you for your time.
Mm-hmm.